So today we want to have a conversation on understanding family law, and especially the law of marriage. There's a Marriage Act in this country. And it recognizes marriage in Kenya in three ways. Either you go to the AG's office and the government and you have a civil marriage registered, or you use your religious route, so Christian, Hindu, or Muslim, or other recognized religions, and it's also registered, or you use custom. And you don't have to then do customary and then go to the AG. Custom is recognized. It's never been very clear to me how custom is then registered, whether you have to then go on with our wazees and say, ndio hawa wazee, ndio hii certificate. Because, all these other guys will give you a certificate.
Yeah.
Right.
But that's why we've invited the principal magistrate at the Milimani Family Court, Gerhard Gitonga, to come and take us through that, getting into marriage and then getting out of the marriage, particularly when it comes to customary. Good morning, Your Honor.
Good morning, Eric, and thank you, team, for having me here once again. It's always a pleasure to be here to discuss family matters, which are very dear to me. I remember the last conversation we had, I said that under Article 45 of the Constitution, the family is recognized as the fundamental unit of the society from which order flows. So that if there's no order in the family, then most likely there's no order in the nation, including this nation where we are. That is not to say that order can only come when parties are together. In instances where, for example, the court is persuaded that this marriage is irretrievably broken down, then we find order to come from separating the parties by way of divorce. So that ultimately what we want is a situation where you have, if parties are living together happily, that is the best ideal, the ideal situation. But where they cannot live together, then we bring order, a different kind of order, by separating them. Now, that said, I think today's topic you're saying is about dowry and in respect of marriages.
Yes.
And I like the way you started by bringing out the three types, and...
Sorry. Before we go into the three types, Your Honor, just
Yes.
a quick one.
Yes.
Janu wants to share the quote of the day with you, and then we can get into the three types and the legal lines there.
We didn't even do the quote, did we? I don't think we
even
did.
we didn't.
Even we didn't do it.
Yeah.
So
it's one of those days.
It's one of those
Today's
days.
that day.
It's
Yeah.
really, no, there's a lot. There's a lot to, but this is from, she's called Amina Mama. She's Nigerian, Ghanaian. She's a feminist scholar. In 2019, she said, if we do not name our oppressions, they will disguise themselves as culture.
If we do not name our oppressions,
They will disguise themselves as culture. Yeah.
Wow. Apewe soda baridi.
Yeah, no.
That's a deep one.
Yeah.
Very
How do you, just tell us your understanding of it and what you think you're concerned about that is often disguised as culture, but it's actually an oppression.
Like I said, that's very deep, coming from, you called her Amina?
Amina Mama.
Amina Mama. Of course, especially in the context of Africa, where culture is a darling, if I say so, we have so many cultural practices, or rather, which on the face of it may look very, beautiful, harmless, and yet therein lies the oppression that may come out of it. If you go to a community, for example, practicing female genital mutilation, and I say that with respect to communities that practice that, it may appear like this is the time-honored culture they have practiced for over years. But the question is it good, is it bad? And therefore, that is why I think she says that if we do not name, then it's our oppressions, they can easily disguise as culture.
Okay, you've explained it really well.
Yeah.
Now you were threading from what Eric had started saying.
Yes.
Yeah.
And I was saying from what Eric is saying, normally Eric was referring to Section 6 of the Marriage Act without knowing, in the sense that that provision of the law provides the various types or the different types of marriages that are recognized by our law. You did mention about the Marriage Act. Now, the Marriage Act is what we call in legal terms an amending and consolidating act. And that is important because you see, previously we had so many acts of parliament regulating the aspect of marriage, but they were consolidated into one. You would have African Christian in the Marriage Act, you would have the Civil Marriage Act, there were so many acts regulating marriage. But what we have now is one which has taken all the various marriages we practice in Kenya and put them under one umbrella. Now, and that is the Christian marriage, like he said, that is the civil marriages, that is marriages which are described as having been contracted using the rights and customs of our communities. That is customary marriage. And then, of course, we have the Hindu and we have the Islamic marriage. All of them are put together under the Marriage Act 2014. Yes.
Now, my question was, in the customary one, what do you get to symbolize the official recognition of this marriage by law? The others, you get a certificate.
Yes.
The pastor will give you a certificate. You go to the civil offices, you'll get a certificate.
Yes. It is interesting to note that even in customary marriages, you actually get a marriage certificate. Again, by reason of what we have just mentioned about the Marriage Act consolidating all the laws. Now, the only thing that brings, or rather that differentiates customary marriages from the others is that, number one, it is recognized that these are marriages contracted under the customs and the rights of our communities. And communities, of course, I'm having in mind the Luo, the Luyas, the Kikuyus, the Kambas, the Merus, all that. Now, when parties set out to contract a customary marriage, they go about business in terms of complying with the rights of that particular community. Where dowry should be paid is paid, and many other things that happen as a precursor to the main marriage. Now, what happens then, the law recognizes and says that the moment you fulfill the customs of that community, then now you alert the registrar of marriages. You see? And the registrar now inquires into whether the particular customs of that community have been complied with, so that at the point in time when the marriage is being registered, because it will be registered, you have complied with the rights.
Interesting.
Yeah.
So there's somewhere where there sits like a list of community to community what is required to fulfill a customary marriage.
You will not, because customary rights by their very nature are not documented, neither are they, of course, written.
So how will the registrar know?
I know.
Yes.
When the parties say we did it, you have to trust them.
Yes, the parties, remember, will also have witnesses who are saying that, yes, we attest to the fact that X and Y have complied with the customs of the Kikuyu for purposes of marriage. Yes.
Okay.
And therefore, the registrar will now go ahead to issue a certificate of marriage. So that in the fullness of time, anytime you talk of all the 5 types of marriages we have said under Section 6, then the ultimate proof is actually the marriage certificate.
You have to have a physical certificate.
Yes.
So people can do the customs and not necessarily do the church wedding, but as long as you have the certificate, it counts as a marriage certificate.
And it is a certificate of marriage issued as a proof of a customary marriage duly contracted by the parties. And I know this is where the confusion comes in, because you're saying if then all marriages have certificates, then why do you talk of customary marriage? Why do you talk of Christian? I think it was the intention of Parliament when they were legislating to bring order into the realm of the space of marriages. Yes. And I think for viewers and listeners, it is important to know that, in fact, when you appear before court of law, seeking, for example, dissolution of a marriage, the question that the court first addresses is whether there's a valid marriage for purposes of dissolution.
Right.
And if the court were to answer that question in the negative and say that for all intents and purposes there's no valid marriage, then you would not even proceed to the next step to see whether there are grounds for dissolution in the first place.
Have you dealt with such cases in your in your court where people have come and they say they were married customarily,
Yes.
but they don't have a certificate?
Yes, and many of them, Eric, and I think, again, that's an important question because you see, the Marriage Act 2014 came into force in 2014. As you would imagine, there were countless marriages contracted under African customary law, and once we pay dowry and do all those other things that appertain to it, then parties are deemed to be husband and wife.
Yep.
Now, when the law brought in the aspect of the requirement for registration, of course, you would always expect that so many marriages would be locked out of that act if you didn't have provision to accommodate them. So two things happened. Number one, for the marriages that had previously been contracted under customary law, of course not registered, a grace period was given for registration. Actually 3 years within which to bring it now under the Marriage Act. Then that is
So
one.
this is 2014.
2014. Now we're talking of
2017.
2017.
Okay.
For the existing marriages under customary law. Now, the new ones, of course, if you are contracting now, the expectation is that you would register. There is also, and this, the law, usually we say, the law does not bring absurdities. You know, it must be logical, it must, of course, look at the ground, the way things are. And therefore, there's a clause or a section in that law, the Marriage Act still, which you normally call the saving clause. It is section 98. If you get your time, you can have a look at it. Now, that section now says that notwithstanding failure to register, you know, that is again now meant to save those marriages again, notwithstanding the fact that those pre-existing marriages have not been registered, they will still be deemed to be valid. It was meant to, because you can imagine, I would even estimate probably at even 60% of customary marriages, of course,
Don't have
are
certificate.
still out there, you know, without registration. So a court of law will always address itself to those realities on the ground.
Okay.
Yeah, so we don't want to say this is not blah, blah, blah. But then there would be an argument as to the place of a customary marriage which has been contracted last year, for example, and it has not been registered. Now, that takes us to, and I think this last part now of that question, when you bring in a customary marriage which is not registered, again, there's a provision that says that an unregistered marriage is voidable.
What are you voiding? What are you voiding?
It's in a sense recognizing the fact that on the face of it, when you have complied with all other things other than registration, it is valid. However, it is voidable at the instance of a party turning around and saying, in any case, we have not registered this as per the law required, and therefore, we ask you to make it void.
Right.
Yeah.
And it's possible.
A lot simpler
than going through the process of. So wait. So what can you? Can somebody legally return dowry?
Yeah, let's start from there.
That's a hard one.
So let me
you want to-
rephrase. Not even.
It's okay. Thread. You probably want to contextualize.
Not even. Now that we are following due process, dowry is part of the process for many communities. I don't know any community that doesn't give dowry. Depends on it.
In one way or
one way or the other.
Yes.
So then, do we follow
Right
due
price.
process when undoing the marriage?
Yes.
That's the word. Yeah.
Yeah, well, the concept of dowry, by the way, is recognized under the Marriage Act. And I say recognition because if you went to Section 2, basically it's the definition section or the interpretation section, it makes mention of dowry. It defines dowry as a token, and I want us to mark those words.
Token.
Yes, because it will inform our discussion. A token of stock, and by stock here you can have in mind, cows, goats, sheep, camels, in some instances, or goods, or monies, or any property given in consideration of an intended marriage. Given in consideration of an intended marriage. Now, let's go back to the word token. I suspect, because it has been used twice in the Act, as Section 2 and as Section 43 of the Act. Now, but it relates exclusively to customary marriages. There's no mention of a token in respect of Christian marriage or civil. It only is mentioned as it relates to the African customary marriages. Now, then, and I'm trying to get to the question. Now, the question then would be, if you describe it as a token, not bride price, then
unarudisha nini, it's a token.
Yes, then the argument would be, on the face of it, the argument would be that then are you returning the gift?
What does the custom say?
We're getting there, thank you, Eric.
Thank you.
And the reason why I wanted us to look at it from that perspective, then we'll come back to the law and the customs, is that in the colonial period, we had a very interesting scenario. We had a clash of laws. We had, of course, having been colonized by Britain, of course, on the one hand, they were seeking to apply their own personal laws and common law on us. But remember, the African man and woman has always had their own laws and customs. One interesting case that I think would be fair to share with our viewers and listeners was a case which was determined in Uganda in 1907. Of course, that is during the colonial period. And it has a very strong bearing to the discussion we have today. Why? Because there was a man called Amkeo. Amkeo was charged with a criminal offense. It was alleged that he had stolen some animal and slaughtered and eaten and hid the hide under some bed. Now, the only person who was privy to those facts was his wife. The prosecution knew that they had no other evidence other than the evidence of the wife of Amkeo. So they sought to call her as a witness. And the argument then was that, is the wife of the accused person a competent person and therefore compellable to give evidence in court as against the husband? Now, the prosecutors, of course, the colonial prosecutors argued that the question that the court needs to address first is whether a wife married in the context of African customs, where bride price is paid, whether she is a wife as understood in the English context. Because they argued that this is wife purchase, and therefore she's not a wife. You get that argument?
That was the argument they used.
And when the court...
That's human trafficking.
Wow.
Low-key. Sounds like that.
So when the court now started to address itself to that question, and everything was revolving around that aspect of dowry payment as a bride price, as a purchase, you know? And the court, of course, in its absurdity, said that indeed this cannot be said to be a wife, and therefore, if she's not a wife, then she is competent to testify as against
the husband. Or this fella.
Yes.
Oh, yeah.
Against the husband in court.
Yeah.
So now back to that question. There will be two schools of thoughts about the question of dowry vis-a-vis the refund and vis-a-vis marriage. One school would argue that as long as you say that what we pay is a token of appreciation, a symbolic way of bonding the two families, then one would argue that in that context, you cannot refund. But and that's one school of thought. The other school of thought would say that dowry is paid not necessarily as a bride price per se, but as a symbolic way of signifying the start of a marriage.
Can we pause there?
Thank you.
Don't
Just
lose your
because
trail
of
of thought. We just need to go into a break. I'm niko kwa refund. Very curious. But we have Gerhard Gitonga, understanding dowry and marriage rights. That's the conversation we're having. It's coming up to 7:30. You can weigh in as well. We'll be back after this short break.
Good morning, Nation Fixers. My name is David Slade, and I am a recovering alcoholic. I have a story of alcohol addiction for 16 years, and I have another story of uninterrupted sobriety of 4 years and 4 months. How I'm fixing the nation. I am organizing for a Kindu Bay Sobriety Half Marathon, which will take place on the 23rd of December 2025, which will feature 21 kilometers, 10 kilometers, 5 kilometers, and 3 kilometers fun and walk family run. The marathon is set to create awareness on alcohol and drug abuse, and the focus mainly is on mental health. And I'll be willing to share my story of addiction for 16 years.
Thank you so much to our fixer, Davis. There, nilikuita Alex in the first one. My apologies for that. It's Davis, actually. And that was a wonderful What's Up Nation. You've done a great job. I think what you're doing within your community to help others with their sobriety journey as well is so commendable. I hope the Kendu Half Marathon goes amazing. And yes, we would love you to have you on talking about your fight with alcoholism, and of course how you've gotten to this place where you can be a champion for others, not just for yourself. It's true growth. Please send us your What's Up Nation video to 0112 500 400 0112 500 400. Put your phone in landscape, sema jina lako na kile unafanya. Could, for example, say, my name is Gerhard Gitonga, and my bit in fixing the nation is ensuring that Kenyans have an understanding of marriage laws, whether they are customary, whether they are religious, whether they are civil, right? And that is threaded throughout their lives. That's my bit in fixing the nation. 0112 500 400.
Did you give? I think he gave us a WhatsApp. No, did you give us a WhatsApp Nation last time?
Yes.
I think you
He
did.
did.
The way to fix the nation is to fix the family.
Yes. He
Memorable.
did.
Kikombe has said on YouTube, I'm sitting here listening and questioning my conscience in my marriage, asking myself, ama sijaoa majameni. Just if you have a marriage certificate, I think you're fine.
Yeah.
But we have somebody who is very well versed in studio to answer. Somebody else, could the guest outline the nitty-gritty of divorce and the causes, maybe the wealth division, therein custody of children? Hakuna refund nafuatilia Paul Minor. See your life.
Janet fuatilia ya maneno ya refund. And we'll get back to that. There's also a few questions on comments on tribalism and basically the fact that it's fading. Beno Cheng says tribalism is slowly fading away amongst common citizens. Leaders who are still strong tribal bigots are there. As long as we allow them to have influence, then it's not going anywhere. Someone else had said that the tribal voting can also be ideological. That's Mama J. For example, the Mau wa Kikuyu fighters who are fighting for their land. Kitili Kakundi amesema World Bank must hold this loan until after the next general election. That's the loan on the front page of the Business Daily.
Yep.
I agree. Hiyo pesa ikome tu hapo for the foreseeable future.
Yeah. Absolutely. So we're back in conversation about understanding dowry rights, marriage. Just before the break, you were saying that there's two schools of thought. Yes. Did you give both of them? You gave one.
No, I gave one.
You gave
Thank
one.
you. Yes, we were saying that, just for a recap, that one school would run that if this dowry is given as a token, like an act of appreciation that you're giving us a girl that you've taken care of over years and all that, then the question would be, what would be the moral basis of refunding? Of course, the law doesn't concern itself so much with morality. The law is the law. Now, the other school of thought would run that if dowry was paid to signify, because most of the cultures, by the way, African community cultures, dowry is paid to signify the marriage itself, the start of a marriage. Therefore, the argument that would run would be, at the end of it, one way or the other. Then what signifies
the end?
The end. And therefore, there's a compelling argument that indeed a refund of dowry would signify now the end of the marriage. Then there would be the question of to what extent, and this will vary from one community to another, to what extent are you refunding? Are you refunding the entire stock, now that we mentioned stock in the Act?
Plus inflation.
Plus interest.
Yes, are you refunding the entire stock of 30 cows, if that is what was paid? Are you refunding a portion thereof? All those questions will arise. But remember, our culture is also, our practices are also very, very much refined, if I may say so. Because they would provide instances where, for example, all of it should be refunded, some of it should be refunded, and this will vary from the Kamba community to the Kikuyu community to the Luo. And in some communities, they will say it's just, for example, a cow or 2 or 3, just to signify the end.
And you've seen that happen.
I have shared with people who have done it in terms of this is what happens in our community, we do this and that. I wouldn't say that in my life, and it's not a very short life, I have seen it from where I come from.
Should dowry payments be regulated under law? Or would that bring... No.
No, go on.
Okay.
You're onto something.
I hear you.
By the way, I am neither for or against, guys. Please note, I come as I'm very impartial.
Go on.
No, I'm just wondering if dowry payments should be regulated under law to give some sense of clarity and closure.
Let me ask. I think to answer that question, I would say it's regulated.
To prevent exploitation.
It's already regulated by the custom.
Does that hold?
That's okay. That's the question. Are you actually going through the custom, or are you now mixing other things?
Well, add the custom to the law.
Because if
like in
writing,
right? Okay.
Because that's the point. If for us to recognize this marriage, the Registrar of Marriages has to actually satisfy that they followed custom. It has to be, what does the custom, does this custom entail? How do you quantify this dowry?
Then write it down broadly.
Okay. So, because we see then that mixture of things where people now say, we are going to, it's a compensation, there was, nani alikuwa anabeba maji, talete maji, and so on and so forth, and nilipeleka shule. Customarily there was not things like nilipeleka shule. But these are now things that have come in, and maybe you can say culture is evolving. But if it's already there, it's an agreement. Come, fika mahali, and the people are, and I think even customarily, if this family did not want this union to happen, they would start bringing in other impediments, which would make you guys feel,
we have been fought.
Which is the same thing you'd find here. Unajua sasa, nataka tank 6 za maji, na tank moja ni 1 million, and so on and so forth.
To frustrate the process.
The message you're being given here.
Yes, and thank you, because the two of you is actually a legal issue you're raising.
As you answer that, please, najua mko na maswali, you can call in. Our lines are open 0719-038-858, 0719-038-858.
Amesema Latif is very attentive.
He's very attentive.
Sorry, go on.
Magistrate.
No, yes, I was saying Janet and Eric, you raised an important legal issue, whether we should actually now, for the sanctity of the application of customs and customary law, whether we should, legislate. Now, my answer would be this, and it's born out of, case laws that have been there. It would be very difficult to legislate on customs. Remember, they are as varied and diverse as our own communities for the 2+. Now, what the approach of the court has been is that, and this arose out of a case decided in 1965. Today I'm taking you back in history. There was a case, it's called Kimani versus Gitonga, where the parties sought to rely on customary law. Of course, the court then was largely a white man's court. And they said that when the African customary law is neither documented nor, there's a word they use, you know, what you take judicial notice of, things that are very obvious. Wakasema, then evidence must be led by the party seeking to rely on it. If you're saying, for example, dowry was paid in accordance with our Kikuyu customs, then it is upon you, you bear the burden of proving that indeed every aspect of that custom was complied with. And we have adopted that approach even to date in court, because I'm not likely to have an act of parliament regulating Kikuyu, you know, customs, another one regulating the laws and all. So what the court does today, when you come to court and say, she's my wife, we got married this and that, and we complied with customs, it is upon you. You remember the old saying that he who alleges must prove. It is upon you to prove. So that is the reason why I think we may not legislate on it, but we are able to deal with it when it arises.
The other bit then, Your Honor, is the fact that we actually do hybrid marriages in this country. So we will register this through church and say it was a Christian marriage. But we'll have started with custom. You'll have done those whole things of, you know, radios and the coitos and all this. What's the company called? You'll do all those things. And then you will end up in church, you get married, and you'll get the church certificate. When the marriage is dissolved, is there then a compelling to reverse the non-registered customary bit? Because remember, it was not registered. What was registered here was the church one. And we have come and dissolved it in your court. And you followed. How did you guys get married? Civil? Okay. How did you guys married? Church? All right. But we are not mentioning that we did this customary one, where there was bride price.
Yes, I think almost invariably, every marriage contracted, whether as a civil marriage, whether as a Christian marriage, there is, at the background of it, there's always those traditional aspects that are undertaken. The payment, the visitations to the other family and all that. But I think, and I have had occasion to read through some of the judgments by the High Court, and because of the hierarchical arrangement of the court, a decision which is made by a High Court is binding, for example, upon me on a matter which is similar in terms of facts. Now, I have seen decisions that have been made by High Court. I think a High Court sitting in Kisii, another High Court sitting in Nyamira. I think you guys may have read through the papers, in the papers as well. When you come in court and the certificate of marriage is clearly showing that yours was a Christian marriage. And remember, when we were starting, we said that the aspect of token that is paid is only restricted to African customary marriages. My reasoning, therefore, would be that if you come to court and yours is a Christian marriage, and one of the prayers after the dissolution of the marriage, one of the prayers you have included there, you are saying, yes. I would find it difficult to make an order to that effect, because I'm saying this. The legal regime under which you have contracted your marriage has no place for dowry payment. Whatever you may have done then, it's not recognized in terms of the regime under which you have registered the marriage. And so would I also argue in terms of a civil marriage. And the decisions I've mentioned about the High Court giving, both of them appear to have arisen out of considerations of a marriage setup arising out of customs. I do not know, and I suspect the court would not be persuaded to to make an order for refund of dowry in an exclusively civil marriage or a Christian marriage. I am yet to see that. Personally, from where I sit, I wouldn't make that order. But remember, like I said, I'm a small court, of course, in the context of the larger scheme of things.
Right.
Yeah.
Okay.
I think if people decide to go through a process this way, and you feel that you're binding yourself to that process, then honor the process. I think
that's what. Yeah.
What does honoring the process mean?
Honoring the process would mean that if in this process, in our custom, there was all these visitations, all these meetings, all this back and forth, and then there was the payment of dowry.
Yes.
And in this custom, if the marriage broke, there would be a return of dowry. And you've subjected yourself to that process, then honor it. Whether you've now gone to formalize it through civil or Christian, then I think it just calls upon you. If you subjected yourself to it, then go through it full hog. If this custom dictates that you shall return one of the 17 cows, return the one of the 17 cows. If it is return the 17, return the 17. Or have a conversation with that family.
About
how do we go about me returning these ones?
To symbolize, I mean, it's fair. If you did go through the process, which now also makes it very heavy, because we do the hybrid. If it was just one or the other now, if it's, a customary marriage and you're returning one of the 17 cows or all 17 cows, that's one thing. But now if you're going through a court process, a lengthy divorce process, on this other end, you still have dowry to return. On this other end,
it's heavy, but it's
a
dissolution. Now, you can't...
You're where you are.
You're where you are.
Yeah.
So if you feel the pain once,
Lucy
and
Gang
go
saying,
through the...
For me...
let me just read this comment, Your Honor, before you come in. Lucy is saying, this giving back of dowry is so unfair, especially to the woman.
Yeah.
The man will take this same dowry to another girl's parent and comfortably move on with his life.
And this is Job Njiru has said, people don't take it lightly. One time while I was in transport and logistics, a client's family wished to return a cow that was dowry to the grooms. I loaded it to my truck and headed to the bridal home. They almost martyred my pickup truck. Wait, was he trying to return the dowry?
It sounds so.
Okay, so they almost karibu wachome yo nini, yo gari yake. Not very light matters. But as you answer that, there's something that I would be like if we ended the conversation without talking about, I'd be very sad at myself. Quick one. Where are we as far as dissolution of marriage by mutual consent? I know it's a bit of a, but I've seen the court rulings. If I'm not wrong, there was a recent court ruling that, we cannot divorce just under mutual consent. Tumechoka tu, tumeboeka, ama whatever it is. But please continue with the thread you are on, and then we can go now to the dissolution of marriage by mutual consent.
By mutual, I'll pack that at the back of my mind. Yes, I think, Eric, you make a very compelling case about if parties have subjected themselves to a process which begins with the payments, all that, then ultimately they head at the altar, then one would argue that if it comes to a situation where the marriage now is dissolved, then it's only fair that you undo the entire process. Now, for me, and the reason why, and this is one of the takeaway points that I would like our viewers to take and the listeners, is that we still have to draw a dichotomy between a marriage which has been contracted, registered, and recognized under the Marriage Act as a purely customary law marriage, because the law honors and recognizes that marriage as arising out of the performance of rights and customs. But we must also not forget that there are those that will meet in the streets of Kimathi here, love one another, walk to the AG's chambers and at the registrar's office and solemnize their marriage.
Yeah.
Now, these two marriages, though under the same act of parliament, are actually different. So for me, I would still stick with the question of refund of dowry, which is a process of customs, but which this hybrid aspect, I know we want to retain our culture, we want to have our cake and still eat it, but for me, I would still argue that I'm only going to consider the question of refund of dowry when it constituted and it defined a marriage. Like the way we started and saying that it begins and it ends the marriage. But remember, in a civil marriage, what ends the marriage is actually not whether dowry is returned or not. It is actually a pure question of whether the grounds upon which you have sought the dissolution of marriage, whether you have given evidence to support them. And therefore, we dissolve the marriage without any string attached. And by string here, I mean without even the refund of dowry.
Yes. Which brings us to now dissolution.
Yes.
It segues perfectly.
Yes.
Now the question, recent court ruling on dissolving marriages by mutual consent. I don't know if that's the terminology used, but that was my understanding of it, which is that it's not one of the grounds cited.
It's not one of those compelling grounds in the law.
In the law.
Let's start with that. What does the law stipulate about the dissolution? And then anything outside of that, how do you
grounds?
handle
Yeah.
Yes, the law actually stipulates, or rather gives grounds upon which a marriage can be dissolved. And the law distinguishes again between the various types of marriage. They will tell you, for example, under Section 65, which captures a Christian marriage. They will say a Christian marriage can be dissolved or parties can be separated or divorced, for example, upon the grounds of adultery, upon the grounds of irretrievable breakdown of marriage, which is like an omnibus of grounds, really.
It is.
Yeah, because the moment you're saying the marriage has irretrievably broken down, could be triggered by so many things, including adultery and these other grounds. And then, of course, grounds of cruelty, so the grounds are set out clearly. Now, those grounds, in our language, we say those are matrimonial offenses. Just like you would say a criminal offense. Now, and I'm explaining from that context because I need you to understand that the dissolution of marriage is fault-based. You must accuse the other party of a matrimonial offense and then lead evidence to support the allegation. Therefore, to come now to the question of the consent, because we have tailored our divorce laws to be fault-based, then the argument is that you cannot just hold one another's hands and walk into court and say, Your Honor, we are here to divorce. You understand? Because the question then would be, who is at fault?
Right.
But there's a strong argument, and I think that's where you're coming. There's a strong argument that why go through all this when it is clear on paper that the parties have fallen out. In fact, most of the cases when they file their cases, you will find a petition filed, then either a cross petition is filed or even a simple response where a party is saying that, in fact, I'm also agreeable. But we still have to go through the motions,
Right.
And
find fault.
And therefore dissolve.
When both parties are just like, sawa, tuachane, sawa.
So for us, and we are saying that if and when Parliament finds it necessary to come up with a law or even to amend the Marriage Act and allow divorce by consent, if you can put it that way, then the courts would be at peace with it and we shall give orders accordingly, because if you go and read William Shakespeare's King Henry V, there's an argument there. They are saying there's a character there called Suffolk, and Suffolk is saying that what is forced marriage but a disaster? You understand? So that the moment parties have fallen apart, it really doesn't matter whether there's fault or whether there's this. The bottom line is that they are no longer able to live together.
So you're trying to avoid that. Oh, sorry, go ahead, Mariam.
No, sorry. I was wondering, is there no part of now the Marriage Act only finding only having room for fault-based divorce. Is there no part of that that clashes with either the Bill of Rights or the Constitution as a whole? Because it does seem, it then forces you to stay in a marriage. If there is no fault, it then essentially forces you to stay in a marriage against your will, because a court may not grant you the divorce if there's no fault.
Can I add on to that question?
Yes.
I'm looking at the law itself and the grounds for dissolution. It goes again in grounds for dissolution of civil marriage, customary marriage,
66,
Hindu marriage and all.
Yeah.
And in all of them, there is one of the grounds is irretrievable breakdown of the marriage.
Of the marriage.
What does that mean? Does it need proof? Because then it could just be the window that Mariam we are talking
looking
about.
for,
If we can just both of us come and say, this thing, it is irretrievably broken.
Yeah.
Now you have started arguing like a lawyer, Eric. Because, by the way, if you find those experienced family law practitioners, they have found a way of relying entirely on that ground and conclude a dissolution of marriage in a very, very quick way. And what we would call a clean break, where, each walks away with their own dignity intact without having to get into the nitty-gritties. Parties just bandy that before court and say the marriage has irretrievably broken down, and the other party says, yes, it is true. So that there is no consent in the black letter of the law, yes, but riding on that particular ground alone, you're able to get the orders.
But I was going to say, doesn't that already give grounds for consent? So what needs to be added to make it less binding? Because irretrievably broken down is quite clean, it's quite, but you're saying,
but the other party has to agree.
Yes.
That's the thing.
Yes,
I can't just go and say this thing is irretrievably broken, and then it's like, no, it's not.
Which happens. It was mutual consent.
Yeah, it's mutual consent.
Yeah, the consent we are talking about here, and the viewers and listeners should probably get this, is, for example, when you look at how we handle children cases, we can have, for example, what we call parental responsibility agreement. Drafted by counsel, both lawyers out there, they only file it before court for adoption to become a court order. Now, we don't have that scenario under the Marriage Act. Much as you may want to use irretrievable breakdown as a ground, it still must be pleaded, and then you must bring in elements to disclose that breakdown.
To show the breakdown.
Yeah, you must bring that, that evidence now to support the ground.
Oh my!
Okay. So there's no fault divorce. I don't know. English,
you're not blaming.
We don't have that.
We don't have that.
We don't have that.
The blame has to go somewhere.
Fault must be allocated somewhere.
Okay.
Yes. Okay. Msani, Kerry, Jeff. Just before we say goodbye to our guest, saying, to us believers, marriage is an institution created by God. Because of cosmic conflict, Satan is out to destroy this institution by all means. Always pray for your marriage. Then Mumo Irungu says, like it or not, marriage is the primary ingredient sustaining humanity. The other thing is that it becomes this. I don't think anybody is disagreeing that marriage is a wonderful thing. It's just trying to get into what happens when things don't work out and how do we do it with dignity.
True.
Like yes, Sunny, and yes, Mumo.
We agree.
In agreement,
I agree with him.
It is. In its best form, it's a wonderful thing.
But
how do you make room for if things break down to protect each other, protect children? I think that's really what to keep in mind.
Yes.
And equality.
Sorry, there's a comment here from Kelvin Wanyonyi. I think, Your Honor, we might have you a third time. There's too much malice in dowry negotiations. You walk into those negotiations these days, you would think they're bidding for art in an art gallery. And we were discussing that over the break, which is that I think dowry changed from dowry to bride price from the white man's from the colonialist interpretation of it. Came and saw like a buying and selling, and then it became bride price, and that's how we ended up.
And it can be very ugly.
Thank you so much, Your Honor. It's been an amazing hour. We've broken down a lot of things and have a lot more clarity. Hashtag is Fixing the Nation NTV. We've been with Gerhard Gitonga. He is a principal magistrate at Milimani Family Court. Yes. And of course, he has been a fixer for a very long time. Hopefully we get another What's Up Nation video from him. But asante sana, Your Honor.
Thank you.
I will be right back.